rise. Bankruptcy court is now in session. Judge Dore presiding.
Good morning. Please have a seat. All right, it's Friday motion calendar. A couple of matters today. We have a few people on the phone as well as those in the courtroom. So for those of you who are on the phone, if I just remind you to mute your phones on your end until I get to the case you're interested in. And when I do get your case, if you would just wait until I prompt your appearance so that we're not talking over each other, I'd appreciate it. So let's start with Nelson versus Wade. Let's see, Ms. Lane, are you on the phone this morning?
Yes, I am. Good morning, Your Honor.
All right, good morning.
Good morning, Your Honor. Jessica Cox.
Good morning, Ms. Cox. Let's see. Ms. Lane, I guess I'll just start with you. Why don't you go ahead, if you would.
Sure. This is a defense's motion to stay the proceeding or alternatively continue all trial deadlines, including the plaintiff's motion for summary judgment. I just want to point out to the court that the court did order at DCF docket number 30 that all the response by plaintiff was due at noon on the 12th, and they filed their response late at 12:22.
You know, actually, I don't think they did. I'm not sure what you're looking at, but at least on the docket that I look at, it looks like it was filed at 11:20, not 12:20. So I consider it timely, and I am going to consider it.
Oh, it's on my side for some reason it says 12:22. Okay, good to know. So we're asking for we're actually asking for to stay the proceeding because the default judgment is still up in the appeals court that is happening. If the appeals court ruled in my client's favor, then this whole adversary proceeding would just go away. I think it would save judicial economy for us to actually stay the proceeding until the appeal is decided.
Okay, let me ask you a question about that, because I'm not sure that I agree if that's what would happen, and maybe I don't understand the state court appeal well enough, but it struck me if the state appellate court agrees with your client, I mean, why wouldn't the result of that just be that you'd have to go to trial in the state court? I mean, how would it just mean that your client wins?
It would. So this whole adversary proceeding is based off of a default judgment.
Right. So there'd be no default judgment, but I mean,
there would be no.
You'd still have a claim. Wouldn't you have to litigate the claim? I mean, right now they have they've got their judgment, and if that gets overturned for due process or whatever the various arguments are, wouldn't the appeals? I mean, I think it would just be a remand back to the state court, and then you'd litigate the claim on the merits, wouldn't you?
But the bankruptcy would preclude that.
Well, then you'd either litigate it in the adversary proceeding or you'd litigate it there. I'm not sure at that point, given the type of claim it is, and I haven't really drilled down on that, but that might be, I mean, if that's considered a personal injury tort type of claim, that would be a claim that I wouldn't even have jurisdiction under. You'd end up either in the district court or back in the state court, but we don't need to delve into that today. But I guess the point is the case. I guess all I'm trying to figure out is, do you agree or not that if you win the appeal, that doesn't resolve the substance of the claim in your client's favor?
When it comes to this adversary proceeding, because the whole plaintiff's basis is that they have a default judgment, they're not litigating the actual underlying claim. They are saying that they have this default judgment and they want to enforce the default judgment through this adversary proceeding.
Correct.
So if the appellate court does decide in my client's favor, then all plaintiff's claims in this adversary proceeding are completely moot. They can go back to state court. That's fine. Go back to state court and they can relitigate it. But I'm only talking about the adversary proceeding.
All right. Go ahead.
And if the court decides to not stay let me go back to the statement of proceeding. So by staying the proceeding, I don't believe that it actually hinders either party. I think it would save money for both sides. It would save time for both sides. It would actually even save time for this court. So I don't think staying this proceeding will actually hinder either side. If the court decides to not stay the proceeding, we are asking the court to extend all deadlines by 2 months. We're actually asking to reschedule the trial to June 28th and then extend all deadlines accordingly. The reason why is because my client was unfortunately hindered by my family medical emergency.
Yeah, and you don't need to go into that in detail.
Okay.
I've read the pleadings. I understand.
Thank you. Yeah, so because of that, it prevented me from actually really diving into the case, going through all of the discovery. I asked a plaintiff's counsel for an extension. Their excuse was, I need to confer with my client. I never got a real response back from them, causing me to hurry up and respond to their discovery request. I sent out discovery requests that unfortunately made their response would be due 2 days past the discovery deadline of January 9th. They waited until January 10th to respond, objecting, saying that it was untimely, and so they basically just didn't respond. This has greatly hindered my client. I have been diligently trying to get through all of the discovery, which is, on my side, quite vast. And so we're asking the court, if you do not stay this matter, if you can, please just continue all of the deadlines. The plaintiff says that would hinder them. I don't see how. Their client holds himself out as a public figure, that he is financially stable. My client just filed bankruptcy. He works as a waiter. So for him to say that he would be financially hurt by this, I don't see how. My client would be the one actually more hindered in this if this either wasn't stayed or deadlines were not extended.
So let me ask you this about the discovery piece.
Sure.
And I guess I want to narrow it a little bit. I understand your arguments about the general discovery you might want to do if this case ultimately had to be tried. But focusing just on the summary judgment motion, I mean, what discovery would be relevant to that? Because as I read the motion, it's just based strictly on whether the preclusion doctrines apply here or not. So what discovery would be relevant to that issue or necessary for your response to the summary judgment motion, as opposed to maybe the bigger issues at trial if it's not disposed of on summary judgment?
I'm still going through all of the court transcripts from the state court to determine that, because it's my understanding that a lot of these claims were actually not litigated. The plaintiff says they were. And so I'm going through the court transcripts looking to actually see what happened in the state court.
Okay. And I could understand maybe you need additional time for that, but that's not discovery, right? I mean, you don't need any discovery to do that, do you?
Potentially I do, because the opposing counsel representing Mr. Nelson in the state court, and he had about, I think, 4 different counsels in that proceeding, finding out exactly what happened, what they filed, where did they file things, where did they serve things. I haven't received any proof from plaintiff on those, and those were actually requested in my discovery request.
All right, go ahead.
And that's all I have.
Okay, thank you. Ms. Cox, go ahead.
Thank you, Your Honor. I think I might start just in reverse order and just reiterate for the court that we are fine moving the trial date, continuing the trial date to June 28th. I wanted to start with what the parties do agree upon. In terms of the summary judgment, moving the scheduled hearing for February 3rd to potentially do some additional discovery, thus reopening discovery, we think that's improper, particularly given that the summary judgment is only based on legal issues, issue preclusion. And, if we bump that out by 4 months, effectively giving defendant an additional 4 months to respond to that summary judgment, we think we would be prejudiced by that. And we had to comply with the current schedule set by the court by filing that. But we're not opposed to bumping the other deadlines that have not already passed. It's just at this point, there's been no showing. I'm not even sure what additional discovery would be necessary that would necessitate reopening discovery at this point. In terms of the motion to stay, I can say at this point that I can't agree to this, but it's possible we would stipulate to that if, after the summary judgment motion is heard on February 3rd, it's denied. I can't agree to that right now because obviously I don't have client authority, but in discussing this with my co-counsel, procedurally, we agree that if this goes to trial with the bankruptcy court and we do not prevail on summary judgment, then maybe it does make sense for a stay to be in place. But at this point, given that the summary judgment motion is just on legal issues, we do not believe a stay is appropriate. But more importantly, I think for the court to recognize is that defendant has not attempted to address the necessary factors which would warrant a stay. And the court is likely aware of these factors, but the likelihood of success on the merits, there's no brief been filed in the appellate court, so I'm not even sure what the appeal is going to be based on at this point. I don't think.
Yeah. Well, let me ask you about that test that you cite in your response, because I am familiar with the 4-factor test for a stay pending appeal. But I guess my question is that even the test I'm supposed to use here? Because typically that test is basically when somebody is appealing an order that I enter and they want it stayed so they can appeal my order. Seems to me that this is a little different situation. I'm not staying any order that I entered. I'm saying, or the issue is, should I stay my proceeding so that a proceeding, in the state court can conclude. But I was curious why you think that in that context, the 4-part test for a stay pending appeal is the applicable test.
Well, I think just as a reverse, it makes a lot of sense to go through why would this court be staying this action without looking at the likelihood of success on the merits in the appellate court, without doing that. In terms of the harm to both parties, although it's a heightened harm for defendant, irreparable, substantial, and for plaintiff, it's just harm. If I have that standard incorrect, I apologize, but I thought it was, we thought it was reciprocal in terms of going back and forth between the courts and how they interact together.
Yeah, go ahead.
I guess we could, I think practically speaking, if the court wants to revisit a stay after the summary judgment hearing, we're not opposed to that, to renew that motion perhaps by defendant. But at this point, we believe that when we agree, I think the parties agree on the narrow issue of continuing trial to June 28th, if that court is still available, if that date is still available for the court. And moving forward with the summary judgment hearing on February 3rd. And then after that, seeing what the result of that hearing is and going from there. But at this point, given just the legal issues in the summary judgment motion, the issue preclusion, we don't believe a stay is necessary at this point.
All right, thank you. Ms. Lane, you can respond if you like.
I think Ms. Cox even pointed in on the reason why we need to stay. I mean, if they're saying that they're in agreement to do a stay after the summary judgment motion has been heard, why not just do it now? Why put the parties through more work, the court through more work, if they're in agreement to actually even do a stay?
May I clarify? Oh,
Are you done, Ms. Lane? It's a little hard for me to tell when you're on the phone. You guys are...
Sorry. Yes, I'm sorry. I'm done.
You were finished?
Yes.
Okay, go ahead, Ms. Cox.
oh, yeah, I didn't mean to interrupt her. Well, I want to clarify. We're not agreeing to a stay at the end of the summary judgment. We're just saying that that might be a possibility, and we welcome the. We kind of need to take this step by step, we believe, and staying, a summary judgment motion that's based on legal issues. I mean, courts favor summary judgment motions that would avoid trial altogether. Maybe we don't even need to go to trial if we prevail on this. I'm not. I want to make clear I'm not agreeing to a stay if the summary judgment is denied, but we would revisit that with our client if it gets to that point.
All right. So let me ask a question unrelated to this particular motion, and that is, what, if anything, are the parties doing to try to just resolve this dispute? I mean, I look at the debtor here, and if the plaintiff prevails, it seems inconceivable to me that the debtor is going to be able to pay anywhere close to the amount of this judgment, which is now in excess of $500,000. So are you doing anything to try to resolve the case? Maybe I'll start with you, Ms. Lane.
So far, I've not reached out for settlement. I am still going through mounds of discovery. And until I get that all in order. That's kind of part of the point,
right? I mean, how much time do you want to spend on this thing when you've got a client who presumably has fairly limited resources to respond to any judgment? I mean, it just seems at some point that the parties ought to at least, talk, or maybe use our mediation system, or, do something to try to resolve it, because here we are running around in two courts, and I know your client's pro se, I think, on the appeal, but I assume the other side has lawyers in both courts, and this doesn't seem to be very practical from an economic point of view, if this is even an economic exercise, and maybe that's my answer, but Ms. Cox, what are your thoughts about that?
I'm careful to delve into the underlying facts of this case, and I understand that the court has read.
Well, I mean, I've read your summary judgment. I understand what the underlying case is about.
So I think that the level of the defamation that occurred here, I understand that it was based on a sanction order plus a default, and the sanction order is based on defendant's inability or unwillingness to participate in discovery for months in that case. So, the allegations made in the underlying state court action were egregious. And so any mediation, I think in that case, defendant doubled down on his statements and said, no, these are in fact true. I'm not going to inflame the court with some of those allegations today, but so getting the parties together in some kind of mediation, I can't say that we're opposed to it, but those discussions have not occurred yet. I think
it seems to me, I mean, your client sort of has that at the moment. He's already won that piece as we sit here. He's got a judgment saying all this stuff wasn't true and blah, blah, blah. And so really all you're doing in this litigation is, trying to preserve a judgment that doesn't seem very collectible to me, in all likelihood. But I mean, do you need that for the vindication that your client didn't do these things? You've already got a state court judgment that says it. Presumably, if there's any settlement, they're going to dismiss the appeal. Your client still has that, court order. I mean, it says all those things aren't true. I don't know what more he's going to get out of this proceeding, kind of is what I'm getting at, other than, trying to figure out the monetary side of the puzzle, what this guy the debtor might be able to actually pay, on something going forward. Anyway, that's all I want to say about that. I don't want you to have these discussions on the record, but I mean, I think you should both think about it and talk to your clients about it, because I'm not sure all the energy we're spending here is to either of your clients' benefit. That being said, as far as today's motion, this is what I'm going to do, and really it's going to be a little bit of everything. I think everybody gets a little piece of what they wanted here and not everything that they want. I'm not going to stay the proceeding today. My view of this was pretty much exactly what Ms. Cox was arguing. I think a stay might make sense if this case is not disposed of on summary judgment, but I do think it makes sense to have the summary judgment hearing because it appears, I mean, I'll need to see eventually Ms. Lane's response, but it does look to me like it's a purely legal issue of whether preclusion either applies or it doesn't apply. It doesn't really have a whole lot to do with the underlying merits or facts. It's just whether what happened in the state court is binding on me and establishes non-dischargeability. So I think that's a pretty efficient and simple thing to do, and I think we should do that piece. But if I deny that motion, then I do think, or at least I want to consider the request for a stay because it may make good sense at that point to do so. So as far as the trial scheduling order, however, I largely agree with Ms. Lane on this. I will reset the dates of the scheduling order backing off of a new trial date of January 28th. I think I discussed last week when we were here that, my scheduling orders are, from a lawyer's perspective, I imagine quite tight compared to what you see in other courts. I think I set trial dates like 5 or 6 months from when the scheduling order goes out. So it does make people work fast. And when somebody gets into a bind like the one Ms. Lane has found herself in for personal reasons that make it difficult to function at full speed as a lawyer, I think it's fair to extend a little more time. So I will, as I said, I'll issue a new scheduling order off of that January or June 28th new trial date. But like I said, I do want to hear the summary judgment motion. So Ms. Lane, I'm going to give you a little more time to respond to the summary judgment motion, but I am going to leave it on the calendar and give you some extra time to respond. I'm not going to set it off for 4 months or whatever the time period might be. And, if you think for whatever reason that the new deadlines I set, if you don't have evidence or something that you need to respond, well, Rule 56 in and of itself has a mechanism for dealing with that. And so you'll need to use that mechanism and just raise it in the response that you do file. But I'm going to give you 3 additional weeks. I'm going to move the summary judgment hearing from February 3rd to my February 24th calendar instead. And that will make your response date February 17th as far as the summary judgment motion, and we'll just move forward on that schedule. So I'm going to do my own orders here, and I'll do 2 separate orders. I'll do one order on this actual motion that will continue the stay request piece to that same date. I'm going to hear summary judgment on February 24th. It'll set the summary judgment hearing on February 24th, and it'll indicate that there'll be a new scheduling order. And then the second order that I'll enter is the new scheduling order, and I'm not going to go through all of the specific dates on the record because I haven't computed them, but they'll fall roughly in the same line as the dates you have now, except it'll date back from the new trial date of June 28th. So you need to look for that order and and pick up all the new dates that appear in that so that you're all on the same page. All right, any questions, Ms. Lane?
No, Your Honor.
All right, Ms. Cox?
Is the court going to be reopening discovery as a result of this, or just the dates after today?
I'm gonna move the discovery date to wherever it would normally be based off of June 28th date. So
May I just make an objection just for the record?
Yeah. You've objected to the motion, but go ahead.
Sorry. I think reopening it will increase the cost for my client and make possibly mediation even harder if that's really the goal here. I think the discovery, I haven't heard any information about any discovery that needs to happen in this case that hasn't already happened in the underlying case. So if there's something that needs to be that hasn't been litigated or hasn't been provided in the underlying case to defendant should have all the information he needs in that case. I don't want to make this more expensive for my client, particularly given the fact that collection is going to be a huge issue here. He's spending a lot of legal fees just to get this portion of the proceeding not dismissed.
Yep, understood.
Thank you.
Thank you. All right, we'll take Vancel next.